Welcome to our webinar on Educational Surrogate Parent Training. I'm Shirley Swope, Parent Advisor at PEAK Parent Center. PEAK is the Parent Training and Information Center for the state of Colorado for parents who have children with disabilities and other parents. And we are working with the Colorado Department of Ed to present this Educational Surrogate Parent Training. As I said, I'm Shirley Swope with PEAK Parent Center. And I would like you to think about why you are interested in becoming an educational surrogate parent or learning more about becoming an educational surrogate parent. This webinar is to give you information to fulfill that role, which is a role that is requested through the Individuals with Disabilities Education Act. When a parent of a student receives special education services, when the parent can't be located, schools must appoint a surrogate parent to make educational decisions on behalf of the student. It does not require this. You're not required to house the student, feed the student, clothe the student, anything like that. This is simply to help make educational decisions for the parent and the role of the parent at this time. So schools are required to train, or school districts or lead educational agencies are required to have a list of people who have trained to be educational surrogate parents and can fulfill that role if it occurs. Under IDEA, districts have to identify students that need special education services or have special education services right now, and there's not a parent that can be identified. This is not a parent who is living with the student but chooses not to be a part of the IEP team. That parent is identified. You know where that parent is. You know the location of that parent. That parent just chooses not to be involved in school activities or the development of the IEP. It's when a student is a ward of the state or the student is a homeless youth. That's when you can't find the parent, or you don't know where the parent's located. To become an educational surrogate parent, you need to be at least 18 years old and a legal resident of the state of Colorado. You must have no interest that conflicts with the interest of the student. So you can't be, if you're the student's teacher, you can't also be the surrogate parent, educational parent. If you are a police officer and you have involvement with the student in that role, you can't be the educational surrogate parent. If you're the caseworker or for the student, it could be that you can't be the educational surrogate parent. So as someone who is kind of involved with the student, but just with the educational interest of the student at heart. You can't be the director of special education for the district in which that student resides. If you are a special ed director or a teacher or a school counselor, you absolutely can be an educational surrogate parent for a student outside of your district. But it has to be that you have no conflict with your working environment and that student. So as you can see, you know, you can't like work for the BOCES, work for the school district, and also educate the student. But you need to be somebody who has knowledge and skills adequate enough to represent the student in a special education process. You can be a parent of a child with a disability and choose to also take on this role as educational surrogate parent. You would have knowledge of the special education process, and you would have no conflict with the district around that student's need at this time. So training is the responsibility of school districts or the Board of Cooperative Educational Services, or BOCES. And ESPs, or educational surrogate parents, need to update their training every few years. ESPs are also volunteer. There's no money in this. You aren't going to get paid for your time and travel. This is something you're doing as a volunteer for the good of a student who's had a hard time in life. You don't become a student who needs an ESP because you come from a happy home. You just don't. There are circumstances that you're going to need to be made aware of around the student's condition or his living condition or educational condition, but you're not going to get paid for that. So the time you are donating to the student is time that you are donating to the student. You're not getting paid for this. ESPs are placed on a list so that the school districts in which they live can refer to that list if the occasion arises when this need, they have a student who has this need. So they're assigned by the special ed director of the school district or by court order. So a lot of times, or not a lot of times, but well, many times, students who are requiring an ESP because they are youth without a parent that can be identified, courts are involved. And it could be a student that is placed in emergency foster care. Foster care parents can act as, sign as parents. However, there are times when foster parents don't feel comfortable in that role because they don't know the student. The student came to them on an emergency basis. They're just getting to know the student. They don't know special education procedures, and they can request that they not be the educational surrogate parent at that time because they aren't equipped and they don't have the knowledge to really support that student in this setting. Some foster parents are very comfortable being the educational surrogate parent for students. ESP assignments must be in writing. The school district is going to have you sign an agreement that you understand this role, that you're volunteering for, and that you're willing to volunteer your time and services in this manner. And then they have to, the school district has to submit that to the Colorado Department of Education. So you may come into the students who find themselves in these kind of circumstance are students if the parental rights of the have been terminated by the courts. That's one way. And then the student's probably going to have a guardian ad litem. Sometimes guardian ad litems can act in this role as educational surrogate parents, and sometimes the courts appoint them. You're going to be in two systems, the court system and the educational system. And court system trumps educational system a lot of times when it comes to decision making around the student's well-being. So a court may have revoked a parent's educational decision-making authority. Sometimes when we get into really hard divorce situations and there is a real disagreement between the two parents about what's the best road to take educationally for the student. Sometimes the courts will get involved in that and say neither of you are going to have educational decision-making authority, and a guardian ad litem or an educational surrogate parent is going to be appointed to serve in that role. And when that's the case, then you know where the parent is, but the courts have said, no, this parent is not allowed to make educational decision-making. Neither parent has that authority at this point. If the student's parents or guardians, can't be located, we have, there is a population of unaccompanied youth roaming the streets of Colorado. They've been kicked out of their homes. The parents say, never want to see you again. Parents move and don't tell them where they're going. Really hard situations. Parents are sometimes incarcerated, but even an incarcerated parent can have educational rights. So incarceration in and of itself will not dictate that this student gets an educational surrogate parent. If the parent is incarcerated because of extreme child abuse and their parental rights are terminated, even though we know where the parent is, that person is no longer in authority to make educational decision-making decisions for their students. So at that point, the courts could order an ESP to be put in place. If the student has a guardian ad litem, but specific court orders do not include that responsibility for educational making decisions. So if you are a guardian ad litem, you need to clear that up. So, do I have the authority to make these educational decisions, or do we need an educational surrogate parent to kind of step into that role? And if a student has been determined homeless under the McKinney-Vento Act, but homeless unaccompanied, you can be homeless and still be homeless with your parent. You know where the parent is, and the parent still has authority to make decisions. So the school district has the responsibility to recruit and maintain a list of trained educational surrogate parents in their school district or the BOCES area. Sometimes, people move, people choose not to continue in that role of being an ESP. Then the district has this responsibility to kind of check that list and to replenish that list periodically, and they should be looking at that like once a year. If a student shows up and needs an educational surrogate parent, that assignment needs to happen within 30 days of the determination that we have a student here who is homeless or who needs an ESP. So 30 days can go pretty fast. And if you don't have anybody who's trained, if you don't have anybody on that list, then it gets really hard. The director cannot act in that role because that's a conflict of interest. So they have to find somebody who's willing to do that. That's why it's important to have that list. To provide CD with an official written ESP assignment for each student assigned who's going to represent the student as their educational surrogate parent, and what training has that person had. And to ensure that every student ESP assigned to a student has the knowledge and skills to represent the assigned student, just to make sure that this young person has his rights, educational rights protected, and that somebody's looking out for their future. And to invite the ESP to participate in special education at the special education process in the same way they would invite any other parent, and to provide them the opportunities to become acquainted with the student. So that's, how do you become acquainted with a student? How do you see what's going on in their life? How do you have a chance to get to know them? And schools have to provide that opportunity. So it could happen that it happens during school time. So an ESP might be invited to come have lunch with a student or take a student out to lunch during the school day to observe the student in school, to have a time when they can sit together and chat and become acquainted, so the student knows who this person is as the educational surrogate parent, what your role is, and why you're another person assigned to them in this crazy world that they've found themselves in. So in the ESP is to participate in training and follow-up to serve only the assigned student. So you may see another student who really is kind of struggling in school and go, well, what about this other kid? That's not your responsibility, and that's not your place to monitor how a district is providing special education services for any other student other than the student that you are assigned. And just like any parent, when you go in and you observe school and you observe what's going on within the district or within the building, it's not your place to speak up for other students. It's only your place to speak up for the student that you've been assigned to, and see how it's going for that student. And if it's a situation that you feel needs to be addressed, you, as a parent, you could have a conversation with the director of special education and say, this is what I witnessed. I just want to report that with this other student. I know it's not my place, but I thought it would be good if you were aware of that. So there are things that happen within schools that you don't know the background to. It's not your place to judge. It is your place to watch out for your student. And you want to get to know this person as best you can with, so that you can speak to some of their personal attributes, what they like, what they don't like, how you found them in conversation, their background, so you kind of know where they're coming from. And you're there to protect their procedural safeguards with respect to their identification of their disability, the evaluation. You sign for the evaluation, you review the evaluation results, and then you talk about placement and provision of that free appropriate public education, or FAPE. Placement for some of these students is going to be maybe in juvenile justice placement system. They aren't entitled to least restrictive environment if they're in the court system as a juvenile. So, you talk about that, but they still are entitled to an education. And to participate in the special education process as the parent would include attending all the IEP meetings and also attending other perhaps events that the student is involved in, or if they have an awards ceremony or anything like that, or any kind of notification that a parent would receive about the student, you are to receive that notification. So if it's an awards, ceremony, you should receive that if the student's receiving an award. If it's parent kind of, welcome night here for all the parents to attend, you should be receiving that. Doesn't mean that you have to, attend, but it would be nice if you could attend so that you know the community in which the student's being educated. And if it's a way for the district to reach out to parents, if they have a newsletter, you should be getting a newsletter, things like that. You have to comply with confidentiality laws and make sure that you're not discussing the student with people who are on the outside of this whole situation. You certainly can discuss the student with the teachers. You can discuss the student with the special ed staff or related services folks, things like that. But if you're visiting your friend in the grocery store, you don't discuss it. You have the right to deny permission for, or grant or deny permission for the assessments and placement. That's the role of the parent in this case. So if they, if you agree with that, you go with it. It doesn't mean that you're complying with the district simply because the district says this is what we're going to do. As a parent, you would really have that understanding of why. Why are you saying this placement is a good placement? How is it going to benefit the student? And do I agree with that? You can initiate dispute resolution options such as mediation, due process, or state complaint. So that's a right that the parent has. Sometimes an educational surrogate parent may feel intimidated doing that because they were asked to serve in this role by the director of special education. You still have the right to initiate a due process or state complaint if you see things going on that you think need to be addressed in that manner. The special ed director cannot at that point say, we no longer want you as the educational surrogate parent. You're doing your job. You can't be fired from this volunteer position because you're doing your job. If you're doing it in good faith on behalf of the student to protect that student's rights, that's your role. So if you're not participating, if you're not showing up at IEP meetings or getting to know the student or simply attending to sign a form without really asking questions or being involved in the student, if you're not acting in that student's best interest, the special ed director can ask you to step down from that role because they need somebody in that role who's going to be a good volunteer for that student. As long as the student may need the ESP, how long are you going to act in this role? As long as the student needs an ESP, or the student graduates, or the student's no longer receiving special education services, or the legal guardian is able to fulfill the responsibilities, and that could be through the court system. The courts may go, okay, parent, you fulfilled your obligation for parent training, you fulfilled your obligation, everything that we set out for you to do. So now your rights as a legal guardian are restored to you. Or the parent is located and decides to be a part of that student's life again. The special education director may determine that if you're not adequately representing the student, he can terminate the assignments. Court assignment overrides school district assignment. So the student may have an ESP who is assigned by a judge, and the school district can't say, we don't like you. we don't think you're, being fair to the district, or we don't think you're being fair to the student. It's a court assignment. The court system trumps the school district system. Or you can resign. And it's a volunteer position. You can just say, I'm resigning. I can't do this anymore. it would be nice if you gave notification of at least 15 days in advance of resignation so that another ESP could be assigned to that position. But if you win $1 million and you're moving to Hawaii tomorrow, it is what it is, and you can resign. So when are they assigned, and what does the federal law, have to say about this, and why did it come about? ESPs are assigned when they're suspected of having an educational disability. Every district still has the child find mandate, and the child find mandate states that districts must identify students who they suspect of having an educational disability or disability who reside within their district, birth to 21 years old. 21 years old or until you graduate with, or if you graduate with a general education diploma, and you might graduate at 18, and the district's responsibility would be over. You might have a homeless youth who has not graduated, and that homeless youth is 17 years old. And that youth is still eligible to have an educational surrogate parent assigned to them if they need that. If they have not graduated, they're suspected of having a disability, and after evaluation, it's the district may contact an ESP and say, we think this youth has a disability. We'd like for you to act in this role so that we can initiate the evaluation. And so they could do the evaluation, say, yep, he has a disability. And then at that time, you take over as the educational surrogate parent. Or you might have a case where the district is suspecting there's a disability. They do the evaluation. They go, no, this child does not have a disability that qualifies them for special education services under IDEA. So you act in the role for initiating the evaluation, the determination is made, and then your role is over if everyone agrees that, no, this student does not require special education services. They might require a 504 plan, but their disability does not have a significant impact on their ability to learn in school. So then your role would be over. And you act as a ESP for a very short period of time. The Individuals with Disabilities Education Act, the federal special education law, and the Exceptional Children's Education Act, which is Colorado's special education law that aligns with IDEA. They all say that, students have a right to if you're living in our country, you have a right to an education. And you might, if you qualify for an IEP, it's going to be under one of 14 separate disability categories used to identify students. And doesn't matter what your living circumstance is, it doesn't matter where you are, you have those protections under the law. And that process needs to be focused on the student. Here are the 14 categories that you might qualify for an IEP. Autism, hearing impairment, including deafness, serious emotional disability, and a lot of times that serious emotional disability is the one they suspect for students who live really traumatic and turbulent lives, and get them into foster care and get them into the juvenile justice system and things like that. So they look at that one pretty closely. Intellectual disability, the multiple disabilities, when you have more than one disability, but one of the disabilities in Colorado must be intellectual disability. So you can have an orthopedic impairment and an intellectual disability. If they have the same amount of impact on the student, then that's multiple disability. Other health impaired, many students have, that's another category that's really has a lot of impact in our state because attention deficit and hyperactivity disorder, ADHD, is listed as orthopedic impairment. Other health impairment, excuse me. Specific learning disability, that includes reading and conditions such as dyslexia, math, have a disability in dyscalculia, math, things like that. Speech language impairment. Speech language impairment is the most common impairment for young children, although it can go all the way, any student can have a speech language impairment, but it's one that affects young children the most. Traumatic brain injury, vision, including blindness. Deaf blindness. Deaf blindness is a condition when you have both a hearing loss and a vision loss. Very, very, very few students are totally deaf and totally blind. Mostly it's this combination of you have a hearing loss and you have a vision loss. You still can see some, you still can hear some, but the combination makes it really hard for that category. And developmental delay. Developmental delay is generally for children under 7 or 8. And you just are slower in your development. You have a delay in your development. We don't have a category for it yet. We don't quite know what's going on. We're in the process of kind of figuring it out, but we know that you are slower to develop than other children your age. At 8 or 7 or 8, depending on the district too, you have to kind of make a choice after what that developmental delay is going to develop into. So it might be a specific learning disability. At that point, you change it to specific learning disability or intellectual disability or something other than developmental delay. Then infant toddler with a disability is a category for birth up to 3 years old. And those students are entitled to an individualized family service plan. So an individualized family service plan also requires parent involvement and to sign off for evaluations and things like that. The infants and toddlers are covered through the community-centered boards in our state, and at 3 years old, that individualized family service plan, or IFSP, can be, you would do evaluations to see if they would qualify for an IEP at 3 years old. So 2 different agencies. It's the Health Department of Health and Human Services. Health Department is in charge of the IFSP. So they've given that assignment to the community center boards within our state. Then at 3 years old, the school district and the Department of Education takes over. So we'd like you to sort of think about a kind of experience you've had with a person with a disability. Many people have had people within their lives who had disabilities from, the time they were born, and they've always known someone with a disability. Other people have not. So we want you to sort of think about that. How did the disability affect your interaction with that person? Or You know, and what do you think are important things to consider when interacting with a person with a disability? And some people don't recognize disabilities, or they don't consider them to be disabled. Some cultures have a different view of disability and when they interact with a person. And you only have a disability if you use a wheelchair, or you only have a disability if you can't see. But anything other than that, you're just a person. Disability categories are only a way to ensure a student is eligible for special education. It really does not define the person. We want to be really clear about that. This is a student, this is a person. You're a general education student first. You're a general education student who, because of a category that we've determined are disabilities, affects your ability to learn in the classroom. That defined it. It doesn't define you. Because of that definition of a disability, we're going to provide special education services for you. You're still a whole person. You're still a whole being. You still have value that any other student or any other person on the face of the earth has. It doesn't define you as a person. It's simply a way to provide services that we think are going to enhance and help you be successful as a student in school. And the services are to be based on the unique needs of the student, regardless of the category. You may have a hearing loss, but you also might need help in math. You may have a vision impairment, but you also might have speech language issues. So whatever your category that qualifies you does not define all the services that you're going to get or that you may need. And we need to remember that people are more alike than different, and people are good. And when students have a chance to be safe and have a chance to be successful, they rise to the occasion and they learn. So how do we get these students who have this very special need of needing someone to act in their best interest with the school district in determining their education? How do we serve them so that they can be the most successful person they can be in school? So we really have to look at that person first. And that's why using that first people first language is so vitally important. When the law first started, it was the Handicapped Children's Education Act. And the emphasis was put on the disability, handicap. It changed, and it changed around 1990 to the Individuals with Disabilities Education Act, because it was important to look at the person first. So we don't say Susie is a Downs what? Susie is a girl who's in 5th grade who really loves cats and dogs, and she's really bubbly and happy, and she helps her neighbors all the time, and she has Down syndrome. Down syndrome simply is one aspect of a very complex person. Your disability is one aspect of a very complex person. So we don't focus on that. We focus on strengths, and we focus on how we can help this person be successful. So some of the terminology that is happening is that free appropriate public education, or FAPE. And that is a building block of this whole law, that students have a right to appropriate public education, and that the special services that are involved in providing that appropriate public education are free to parents. So if that child needs access to a speech therapist to access public education, speech therapy is free to that student. Parents don't pay for it. Special education and related services, that's also going to be free, but those are the building blocks, those are the special helps that come to a student so that the student can be successful at school. And they can be successful in that least restrictive environment. And least restrictive environment is the classroom the student would attend if that child did not have a disability, adding supplementary aids and services to that setting first. That's what we do first before we move a student away from the general education classroom, because they have a right to be educated with students who do not have disabilities. So special education and related services, they are to be delivered at public expense in conformity with the IEP in the LRE. Don't you just love all these, initials? So it says we're going to provide support within the general ed classroom through supplementary aids and services and related services, and this special education is going to work with the general education teacher and the general education teacher arena so that we can support this student in the least restrictive environment. And we're going to look into the future, and we're going to say, we really want him to have educational benefit from this setting. And how are we going to get him to have educational benefit? School is not a babysitting service. School is not a daycare for kids. School is a place where students are expected to be given instruction in a way that makes sense to them so that they can learn, so they can become independent adults. Because that is our basic floor of opportunity, is education, to make sure that we don't become a dependent on the state only because we didn't have a chance to learn. In Rowley court case, it established a two-part test for a student's education. Has the state complied with the procedures set forth in IDEA? And that includes least restrictive environment, supplementary aids and services, looking at placement, having parent involvement. Those are the procedures set forth in IDEA. And is the IEP developed through the IDEA's procedures? Is it reasonably calculated so that this child can receive educational benefit? Are we looking, do we have good tests? Are we keeping good data on what's happening in school? Are we taking the students' past into consideration? How's it going? And are we using this good data to make good, sound decisions? In Andrew versus Douglas County School District, the Supreme Court determined that when providing special education services to students, they can't simply make minimal or trivial progress year to year. It's not babysitting, but instead to ensure that the student makes meaningful progress given the student's unique circumstance. In Andrew F., the student had experienced autism, and the school really concentrated on behavior goals year to year, and he was not making educational gain. And after several years of that, the parents took him out private school, and then he started making progress. made progress with behaviors, and he made progress with his academics. So it required an educational program to be reasonably calculated to enable a child to make progress, appropriate in light of his circumstance. So in light of his autism, how are we going to help him learn academics along with helping him be more in control of his behavior? And the educational program must be appropriately ambitious. It can't just be learning your colors and you're in high school. It needs to be appropriately ambitious for the student and to have him advance grade to grade as well as he can for most of the children in the regular ed classroom. We want students to learn. We want students to learn academics so that they can have a full life as an adult when they leave school. And that's what Indra stated. So special education. What is special education? It's specially designed instruction to address the unique needs of the child that result from the disability and to ensure access to general curriculum. So specialized instruction, you know, one example is how do you, a reading interventionist is going to be working with the student to help them learn to read. Reading interventionist is going to give specially designed instruction in reading so that that student can access general curriculum. It means really looking at the individual and adapting how we are instructing the student. You know, well, this is the program we bought. All the students have to, you know, go do this program. Well, it doesn't work for this kid. What are we going to do? We need to individually look at how we're going to teach him. And that's where the special education comes in also, to help with that specially designed instruction and to address the unique needs of the student resulting from the disability, and to ensure access to general education curriculum so that the student can meet the standard that apply to all children. So when we're looking at that, we're looking at, okay, how does this kid learn and what do we need to do to change it so that they're still having access to education? What are related services? Related services Related services means transportation and such developmental, corrective, or other supportive services required to assist a child to benefit from special education. So what is that benefit? And what would that look like? And when does a child require speech therapy? Well, you might require speech therapy so that you can, for one thing, other people can understand you and you can be a part of the discussion. Another thing, it helps you develop language skills so that you understand how to respond, how to have a conversation, how to respond to other students, things like that. So FAPE. So we've got the general curriculum. All students are general education students first. You're a general education student who receives services at special education supports for the general education curriculum. Special education supports the general education and the general education curriculum. Related services wrap around and support special education. So you have this support student system for this student who's looking to learn general education curriculum. If you're in 4th grade and you're learning state history, all about Colorado, your special education is not going to be working on something totally different. They're going to be working on how do we support them in learning Colorado history? How can we change the curriculum a bit? How can we add those accommodations so they can really understand what's going on with learning the general education curriculum about the state of Colorado, and then the wraparound services are going to support that effort too. So we all work together for a common cause. That common cause is a student in general education curriculum. And IEPs. So when we're talking about IEPs, which is the Individualized Education Program, hang on. We're going to look at the present levels of academic achievement and functional performance, or PLAP. And we're going to compare that to the general curriculum. And then when we're looking at that present levels of academic achievement and functional performance, compared to where a fourth grader should be, we're going to look at what skills are we lacking and where is that gap in skills compared to the standards that we're looking for that grade level. And then we're going to look at IEP goals. And the IEP goal is unique for every student. It's not at peak. As parent advisors, we get asked, is there a place I can go look at reading goals? Is there a place I can go look at math goals? Well, it depends on, there's some examples of goals and how they should be written, but the goal should be unique for the student. It shouldn't be a goal that's a blanket goal. This is the goal I have for all the students who have a reading challenge. No, because we're all learning differently. And so we have to look at where our skills gap is. And then we have to look at our starting point. Where's our starting point? Our present levels of academic achievement and functional performance. Where's that? Where are we building? How are we building forward from that? There are 3 maximums in the least restrictive mandate of the law. To the maximum extent appropriate, children with disabilities are educated with children who are not disabled. They have a right to be part of the general education environment and the general education population. To the maximum extent appropriate, children with disabilities are able to participate in extracurricular activities with children who are not disabled. Just because you have an IEP does not eliminate you from trying out for the basketball team. Just because you have an IEP does not eliminate you from running on the track team, from the drama club, from the Spanish club, from running for student council, for participating in student life in any way. You may be in a wheelchair, and if you want to try out for track, well, guess what? We have to figure this one out. And if you need some support for your comfort and for your ability to maintain your behavior when you're at a track meet, someone needs to be there who can help you do that. To the maximum extent appropriate, children with disabilities are provided supplementary aids and services to enable them to be educated with children who are not disabled, So you've got 3 maximums, and the IDEA was really deliberate about putting these into the law. They've been in the law since the beginning of the law, because these students are general education students first. They're general education students who receive services through this IEP process. And to the maximum extent appropriate, they are to be in general ed, supported in general ed, and participating in general ed, because that's how students learn. And that's how students learn best. When we look at this FAPE continuum, this free, appropriate public education continuum, here's where we start. We start with that evaluation process. What's going on? What does that look like? We look at our present levels and our needs. So where's our starting point? Our starting point, based on our evaluation, our starting point's the present levels and where those gaps are and what we need. What are our measurable goals that we're going to look at? We're going to look into the future with our crystal ball, and we're going to think, okay, if we provide this amount of support in this way, we can reach this goal and the student can make this much progress. Where's this progress going to occur? Well, in the least restrictive environment, in the general ed classroom as much as possible. And what kind of support are we going to put in the general ed classroom so that this goal can be met and progress can be made, because we're looking at that calculated, reasonable educational benefit. We want them to get the gist of what it is to be a fourth grader and to move forward into fifth grade with that foundation of educational knowledge that we've been building on, so we can move forward as a student who deserves to move forward. Fundamentals. Pam, can you hear me? We're at fundamentals. I paused it. And this is where we were going to cut. What do you want to do?
I've been listening just in case you need it.
Okay. Because you're showing up there.
Yeah.
And so should we just keep going?
Yes, we need to record this because then this is the one that's done.
Okay.
It only took an hour, but people didn't ask any questions.
No, there's no discussion and there's no reason to linger.
No. So let's keep, because this
is
is
it
the
going
one,
okay?
Yeah, this is the one that's recording.
Yeah.
That we're gonna then close caption and put on the website.
Okay.
Yeah. So no, you're doing good.
Okay.
You're doing great. No, that's all. You just keep plugging unless you want to take a break or something.
I just probably need a drink.
Yeah, why don't you take a little break and then hit pause and start again. Just make sure you hit pause. It doesn't show on my end that you paused.
It's paused, and then I'll resume.
Yeah, because it doesn't show that on my end.
Okay.
Because you're the host.
So it's just stopped.
Yeah. So do what you need to do. If you go to the bathroom, you need to wear these gloves.
Yeah, I think I'm fine.
Okay. Well, I'm sure that everything's it's going great.
Okay.
Yeah, I'm listening. I just think it's in case you need it. Yeah,
it's just a lot of talking.
I know. That's why if you want to take a break, walk around the block or something.
Maybe I'll take a little break.
Okay.
Well, I'm on a roll.
Whatever you want to do.
I think I want some fresh water is what I want. So.
You're doing great. Hello? Yes. Oh, I'm good. How are you? Thank you. Yeah, maybe. You just have to start coming back into the office. So I'm in the office. But today would work. Just it's gonna have to be later. Like, yeah, like what if he called me at 2 or 2:30? Yeah, why don't you call me back at 2:30? You're welcome. Thank you. Yeah, good idea.
Okay. Okay.
If you need me, just call me again.
Fundamentals. We're going to talk about the fundamentals of the IEP team. The student's IEP team must be developed and by a properly constituted IEP team. So we don't want improper, we want proper. So the list is, the first on the list is parents of the child. So the parents of the child, and that's going to be the educational surrogate parent, is going to fulfill this role. It's required. Sometimes, once again, Some parents choose not to be involved. The school cannot mandate or arrest them or have them, show up if they choose not to. But they are an essential part of the IEP team. Not less than one regular education teacher of the child, if the child is or may be participating in regular education environment. So we always start with, are we going to be a child? Is this the place you begin? Is the regular education classroom where that child would attend if that child did not have a disability? So the assumption is, yes, you're going to have a regular education teacher there. And that teacher is going to be teaching that child and participating in the development of this IEP. Whoops. Excuse me. Not less than one special education teacher of the child, or when appropriate, not less than one special education provider for the child. If we go back up to the regular education teacher, when you're in elementary school, generally you have a classroom teacher. Mrs. Smith is the 4th grade classroom teacher. She teaches math, she teaches reading, she teaches, the students. They may have a music teacher, they may have a PE teacher that's different. The librarian comes in and out, but their teacher is the regular classroom teacher. When you get to middle school and high school, it changes a bit because now you have a math teacher and an English teacher and a social studies teacher and a PE teacher and a music teacher. So when you get to middle school, very often you're going to have more than one regular education teacher for academics. So schools may appoint one teacher to be, for a child to be the regular education teacher at the IEP meeting for this child. And then that regular education teacher, along with special education teacher, needs to report to and inform the other teachers about the IEP and what their responsibility is to the IEP. So it gets a little more convoluted when you hit middle school and high school. So if you're having a struggle in math and the English teacher shows up, you might want to request that the math teacher be the one appointed to the IEP team, because that's the, subject in which the student struggles the most. So you would really want that input of that teacher. So you can ask, who's going to be the regular education teacher? Who's going to serve that role when we're having the IEP meeting? And request somebody different. Your request may or may not be granted, but at least get it out there. If you don't ask, the answer is always no. So ask, we need to have the math teacher there. Maybe we're going to have 2 general education teachers there, and they're going to tag team that spot. But somebody needs to be there from regular education teacher of the child for the entire meeting, not just part of the meeting. And if you're middle school or high school and you have a person that you feel really needs to be there, ask for that person to be there. A representative of the public agency, that means somebody who can write the check, somebody who knows what the district's resources are and the availability of things, and can provide support for a student if you need to have money involved. And an individual who can interpret instructional implications and evaluation results. So if you had a speech therapy evaluation, Probably you'd like to have the speech therapist there who delivered the evaluation to give that evaluation and interpret the evaluation results. The law now says, though, that you might have somebody else there who can interpret those results, who's a speech therapist in the district, did not give the evaluation, but is somebody who can understand and read the evaluations. A psychologist probably can't interpret speech therapy evaluations. An OT probably can't interpret a psychology evaluation. So it needs to be somebody there who really understands it, so that if you have questions, it can be explained to you in a way that you can understand. So the mandatory members are 5. Parents are really a mandatory member. However, school districts cannot by law require them to be there. So it's general education teacher, special education teacher, someone who represents district with district resources, and someone who can interpret test results. All the chairs must be full for the entire meeting. One person can fill more than one chair, however, not the parent chair. So you still have a general education teacher, can't play the role of special education teacher because that just wouldn't work. But a school psychologist who's there may be a representative of the district. So ask, what's your purpose? And what role are you, what's your purpose for being here? And what authority do you have from the district? So we want to have an opportunity to participate. Parents are equal participants in this whole process. And that was how the law was written. That was the intent of the law from the very beginning, that parents are going to be a part of the team and an equal member of the team. It's hard to be an equal member of the team when you don't work with these people on a daily basis in their workspace. But you're all there for a common cause, and that common cause is the student. They're team members. And they're protectors of the students' IDEA rights. So that's why it's so important for an educational surrogate parent to understand that they are a protector of the students' educational rights. We are a fortunate country in that if you live here, you get to go to school here free. And you have a right to a public education, whether you're or a founding father and related to George Washington, or whether you just came across the border and you're undocumented. If you're in school, you have a right to an education. And schools have the legal obligation to propose an IEP that provides free, appropriate public education. So that's a very important right that you're protecting for students. Parents have the right to object to a school's proposal. It's a balance, you know, parents are there to say, we're really focusing on the individual. We're focusing on the individual. We're focusing on the individual. Schools have an incredibly powerful and important and hard job to look at all their resources for all their students that they're providing education for, and kind of looking at the big picture of, this is our district, this is how we work, this is how our money has to go, you know, this is the space we have, this is the personnel we have. It is a big, complicated picture. And school districts have that daunting responsibility of making sure that their students are being educated in a way that they want, that's best for all of their students. Parents are focused on the individual. And as an educational surrogate parent, you need to be focused on the individual. Doesn't mean that there has to be conflict, but there does have to be a focus on the individual. And parents' job is to really keep the student in mind, keep the focus on the individual, and say, here's the need. How are we going to address the need? You don't ignore a need based on district's finances. You don't ignore a need based on districts' personnel that they have. If a child needs speech therapy, a child needs speech therapy. If there's no therapist within the district, it doesn't eliminate the need. The need's still there. How are we going to address the need? We may address it in a different way, but we still address the need. When a parent is denied the opportunity to participate, or the school makes the unilateral decisions, predetermination occurs, and that is making sure that parents don't have a say. It's like, this is how we do it here. This is, you're here to sign the paper that you were here, but all the decisions have been made and you had better fall in line. That is not what we want to see happen. Parents have a right to participate. They have a right to make sure that the needs are met, and they have a right to making sure that placement makes sense for the student. It never should be predetermined. There is a process to this, and the process is this. First, you have a referral. We think something's going on with the student, or the student has been, identified, something's going on, and I think we need to do an evaluation to determine whether or not there is a disability that might qualify him for services through this IEP process. So I'm going to refer the student, and parents can refer a student, teachers can refer a student, the therapist can refer a student, can be referred in many different ways. But once that referral is made, then we're going to look at, do we need to do an evaluation? And what are we going to evaluate? Are we going to evaluate like everything about the student? We're going to take a big general picture of the student, but reading is really what we're concentrating on. So we're really going to do a good reading evaluation. Then we'll determine, do we need to get his vision checked? Maybe he's not reading because he can't see. One thing may lead to another, but we have a starting point, and the starting point is the kid can't read. So then we're going to see what else is needed. After the evaluation, we're going to meet to determine, is this child eligible for an IEP? You can have a disability and not qualify for an IEP if that disability does not have a significant impact on your ability to learn in the classroom. So you may have a disability of ADHD. The doctor says, I'm going to write a prescription for an IEP. It doesn't work that way. The doctor can determine, yes, here's a student who has attention deficit hyperactivity disorder, ADHD. Take this evaluation to the school and we'll go from there. And eligibility doesn't impact his ability to learn in the classroom to a significant degree. It might. And if it does, then he could qualify for an IEP under other health impaired. It might not. He just may need some accommodations to help him learn in the classroom. Some accommodations may be delivered through a Section 504 plan. But if he does qualify for an IEP, then it would say, yes, we agree. This student does have a disability that impacts his ability to learn in the classroom. So now we're going to develop an IEP. We're going to look at that present levels of academic achievement, functional performance, and we're going to look at those skills gaps, and we're going to move forward in that way. As a parent, you're going to participate in this process from the referral end all the way through. So participation is really important. What do you see, general ed teacher? What do you see, special education teacher? How are we learning and working together? And here's what I'm seeing, here's what I'm being told in the place that the student lives. Here's what I'm being told. Here's our process in the court system. And how does that impact what's going on for the student right now? What kind of services are we going to need? What kind of supplementary aids and services need to be put in place so this student can learn in the general ed classroom to the maximum extent appropriate? Remember those 3 maximums. To the maximum extent appropriate. How is he going to be educated? And what kind of services are we going to provide for him to help him be successful in school? We're going to review it, and then we're going to see how it works. We're going to put it into play. Is this IEP working? What do we need to do? What do we need to do over? Do we need to make changes? We're going to reevaluate. And so we move forward through this process. Evaluation, eligibility, IEP development, IEP implementation, progress monitoring. We're going to collect that data. We're going to make sure that our guesses were good. We're going to review the IEP in 365 days, and we're going to start over this whole process. It's a very dynamic, active process, from evaluation and eligibility to that development, to the implementation, to progress monitoring. We're going to monitor our progress on our goals every time a report card is issued, at least that often. We're going to, did we guess right? Is it working? We're going to start the process over again. This is not a stagnant process. This is an ongoing process that has a lot of conversation going on all during the year. So we start with, every district has that child find mandate for students' birth to 21 years old, not birth to 3, not 3 to 5 year olds, not after that, birth to 21. And if we suspect a disability, and when you have a child who's in foster care and foster families, that child may move around a lot. They may be in a foster adopt situation, but the district in which where he's going to go to school needs to look at this. And then, is this child eligible for services? Just because you haven't had instruction in math, maybe this child has moved around a whole lot and really missed out on the opportunity to have instruction in school. But once you get it, boy, this kid can take off. May not qualify for an IEP because he may be just didn't have instruction. Not having good instruction does not give you a disability. It just means you didn't have good instruction, and the school needs to address that in that way. So the process that we want to look at is, without a clear understanding of the student's educational needs, it's impossible to determine that free, appropriate public education. So we really have to look at the educational needs. Does the disability qualify him for an IEP? Is the student a student with a disability, or is the student in need of accommodations? Academic, functional, social, or behavioral. That's that functional performance. So you may have a child who, once they settle into school and clear, good, safe way, it may, ease up, or it may start to really manifest because now my behaviors, because of the trauma I experienced, are really showing up. Academically, I can understand it, but boy, functionally and socially and behaviorally, I just can't hack it. This is really hard. So that functional performance is as important as the academic achievement. So you have this evaluation wheel that can be very helpful for you because you need to look at the whole child. So I can't read because I can't see, but nobody's caught that. So my physical motor skills are, I need glasses. Once I get glasses, I can see a lot better now, and now I can make progress academically. And then those communication skills, that social emotional skills, those functional skills, you really need to pay attention to those and consider those, especially with a child who is requiring a surrogate educational parent. There's trauma in the past. An IEP is a written plan that's developed for each student who's found eligible, but you can have some difficulties in school and not be eligible for special education, but we're talking about kids who are eligible for special education. And it has to uniquely address the needs of the student based on strengths and needs. And sometimes those strengths are hidden and you really have to look for them, but look for those strengths and then address the needs of the student. It's to be based on data. You base it on something really concrete. You're gonna take note of what's going on, and you're going to see what works and what doesn't work when teaching the student. Then you look at that special education program for the student that is unique for that student. And it's based on a team of people who work together about what's best for the student. It's keeping the student in mind. And the parent's role, the ESP's role, is to focus on the individual, not, well, we have other kids in school who are worse off than he is. We're not talking about other kids in school. We're talking about this student. We're not talking about anybody else. We're talking about this student. Well, we've got a lot of kids who need a lot of things. Sure you do. We're not talking about a lot of kids who need a lot of things. We're talking about this student. So the ESP is to focus it back on the student. Focus it back on the student. You're talking about one student here. There are 3 types of IEPs. The initial IEP is the very first IEP for that student. The very first IEP in a district or BOCES for that student. And that's the one where the parent signature is really important because special education services cannot start until the parent signs that they agree that the district may provide special education services for this student. This is before the development of the IEP. So, okay, I'm going to sign that we agree needs special education services. I'm going to sign my permission for giving that service. And now, after I've signed, now we can start looking at developing the IEP. And in 365 days annually, we're going to review to see, are we making progress? What kind of progress have we made? What do we need to change? How do we need to update our goals? What's going on? And we're going to review and amend the IEP if we need to every 365 days. So that's going to include two school years. It's going to include going from middle school to high school. It's going to include going from preschool to kindergarten. So you really need to, you're looking at 2 school years when you're looking at your annual review. And then every 3 years, there's a reevaluation. You look, do we need reevaluations? Do we need to get a clear new picture of what's going on? 3-year-old's not a 6-year-old, a 6-year-old's not a 9-year-old, a 9-year-old's not a 12-year-old. So what's going on? What do we need to reevaluate? And how do we need to move forward in a really positive way for this student? So the basic steps to the process are that eligibility, the evaluation, the present levels of academic performance and functional performance. It should be academic achievement and functional performance. It's a little typo there, sorry. And the identification of the needs, the annual measurable goals and short-term objectives, and then a plan for the delivery of the supports and services that this student needs for placement in that least restrictive environment. And then who's going to do what, when, and where, that implementation. What role are we going to play, each of us going to play, to make sure that this IEP is moving forward in a really positive way? So when we're looking at those present levels, this is our starting point. This is where we're beginning. This is where the student's going to take off and go. This is where we're going to move forward. Here's our starting line. What is it? And how far are we hoping this student can run? So what are the academic and functional skills that the student can demonstrate? Are they at grade level? Are they below grade level? You know, what standards are we looking at? And what kind of data has been gathered? How has the data been gathered? And how are we going to have ongoing data being gathered? And includes the interests and the strengths of the student, and for, you know, the teachers to get to know the student, and for the educational surrogate parent to get to know the student. How am I going to get to know the student's strengths and interests? How am I going to get to see him in a way that is unique to the other players in this? So as the educational surrogate parent, you may be having talking with the foster parents. You may be saying, you know, getting their opinion on things and making sure that everyone's understanding what you're looking for, seeing them in a positive light, seeing what you can build on, because you want to build on strengths and interests. And sometimes you have students who are so traumatized that it's really hard to kind of get below the surface of their guarded shell. Input from the guardian and parent or the ESP, you know, that's really important. If the parent might be involved but not have educational custody, so that you know where the parent is, but the judge said, no, you can't make educational decisions. But the student might still live with the parent. So that might be one road. The other is, might be incarcerated, and you might be talking with the guards or the person in that setting who's working with that student at that time, and saying, yeah, he's being very compliant, you know, he's following all the rules. That would be something that would need to be reported. So it's important to carefully consider all the students' educational needs. It's not just, well, he's really having trouble in reading, but we're going to, you know, send him on to geometry. Well, got to read math too, you know, we got to look at this. So you have to look at the whole picture. That's why that data is so important, to really look at that whole picture and what's happening with him throughout the day. You may need to prioritize the needs that you really want to kind of work on first. You know, it's really important that we get established with, you know, security around his behavior or something like that, or let's concentrate on reading before we, you know, and give him a lot of support with accommodations around reading and other subjects, so that we can give them some success at school. It can include skills that are necessary to access the curriculum. This is part of that functional performance. And so this is something you really want to look at. Organizational skills, following directions, managing frustration and anxiety, and social skills. Once again, when you have a student who is requiring an educational surrogate parent, there's something going on in the past that got him to this situation, probably no fault of his own, but there you are. And managing frustration and anxiety could be a big part of that. I want to keep that in mind. Goals should be based on the students', prioritized needs. And we, in the state of Colorado, we recommend that you look at SMART goals. Goals that are specific for the student because they're always based on unique and individual needs. You're going to have a measure to them. Even if they're a behavior goal, you need to have a measure. Can this goal be achieved within 365 days? And are we really being realistic? This is what he needs, and this is the priority that we're setting for him. And then you are time bound. And some goals you're going to look at, at the end of the school year, where are we? And we made a goal for the end of the school year, but we're going to, see if we can review it. Other goals, this is, going from this year to next year, and we're working on it in 2 school years. That's why it's really important to always remember that it's 365 days. That's going to include 2 grades. All IEP meetings include 2 grades. This year's grade, next year's grade. So can it transfer pretty easily? The objectives are only required if the student's working towards extended evidence outcomes. They're not taking the same standardized test the other classroom students are taking. And their objectives are identified that are necessary to help reach an annual measurable goal. Generally, this is for students with, pretty significant disabilities or intellectual disabilities. Mostly goals do not. The #1 IEP category in Colorado is a specific learning disability, followed by other health impaired, because that is ADHD, followed by autism. When you have these goals, you're going to, in the IEP, you're going to describe what specialized instruction is going to help the student reach the goal. So what are we going to do? How do we specifically need to teach? And what specifically are we going to teach so the student can reach the goal that we're working towards? And what instructional services are going to be available for that student to help them reach the goal? The student may be working with a counselor and may be working with the school psych for twice a week. Maybe, a behavior specialist is going to come in and work with the student in the classroom to help the student really understand and get control of and manage behaviors and understand, what's causing the behavior, and understand and have ways to cope with that behavior that are healthier than the ways that he's been shown in the past. So some of the other services can include a healthcare plan, healthcare plans for students who are on medications, healthcare plans for a student who has to have an EpiPen. So diabetic, a student with cancer, you would have a healthcare plan. If you have medications at school, you need to have a healthcare plan. Students are not in charge of their medications. If you have a student who is receiving medication for ADHD, he does not carry that medication on his person. He does not keep it on his person. it has to be with a responsible adult, and the healthcare plan will include who that person is and how medication is given. If a child has an EpiPen and requires it to be on their person, an adult needs to be aware of that, and there needs to be a plan on how that is going to look and who's going to be in charge of that student all during the day. So it might be from 8 to 10, the general education teacher is aware that she's in charge of the EpiPen. At recess, the paraprofessional who is on recess duty is in charge of the EpiPen. After that, the lunchroom lady's in charge of the EpiPen. Somebody is going to be in charge of that. The healthcare plan can look at that, but you need to be specific about, you know, administrations of EpiPens, of drugs, things like that. Some students who have diabetes, they need to carry their equipment with them. You know, who's going to be in charge, who's going to know how to support the student. And some students with asthma need to have their inhalers with them. You don't leave it in the office and then expect a student to walk a long way who's having an asthma episode for their, you know, asthma medication. So it's really important to look at healthcare plans if there's any medication or any medical condition involved. And that's something that as an educational surrogate parent, you would really need to know that. Communication plan is for a student who is deaf or hard of hearing, basically. Does this student need an interpreter? Does the student need amplifying equipment to be worn in the classroom? Sometimes a communication plan can also be for a student who is nonverbal, or a student who really has difficulty communicating. Sometimes young students with Down syndrome will learn sign language first and be supported through sign language. As their speech becomes more intelligible and as their speech develops, then they drop the sign and they use speech more. Is there a need for a communication plan? That generally is for students who are deaf and hard of hearing. A vision plan is for a literacy plan is for students who have vision impairment. So you can call it a vision plan, but it's how do we, does the student need large print? Does the student need Braille instruction? How are we going to get information for a student with a vision impairment? Some students need behavior support plans, especially students who have had a lot of trauma in their life, and behavior is a way that they're expressing is their language. So you might look at a behavior support plan. Not every student's going to need a behavior support plan, but there will be students who do. How do we help the student gain control? How do we help the student, how do we identify those teachable moments and work through, you know, learning to de-escalate, learning to breathe, learning to, you know, have some measure of self-control over behavior and express behavior in a more positive way. Is there special transportation needs? Does the student use a wheelchair? So we need a bus with a ramp. Is the student really like to run and it's not safe for the student to, first grader, to stand at the bus stop because of safety reasons, has no sense of safety and will just run into the street? Do we need special transportation services? And what would that look like? Sometimes it's a person on the school bus, a transportation paraprofessional, or an educational, you know, aide to be on the bus with the student so that they stay in their seat and they're safe on the bus. Does a student need assistive technology? And assistive technology can be anything from hearing equipment, the FM system that students who have hearing loss wear, to maybe an iPad for a student to communicate with their communication plan. They use an iPad, or a pencil grip, or special seating. It can be as simple as a pencil grip and as complicated as a communication device, and anything in between. If it's technology that's going to assist you, you need to see if the student needs something in place. Some districts assign every student a Chromebook. Some districts assign every student, a piece of assistive technology. That's part of the general education plan. You might need a special app on your device that was assigned to you in general education. Do you need a specialized app on your assistive technology equipment? That's assistive technology too. So when you're looking at that, many schools now are using iPads, or they're using Chromebooks for students. What do I need on there? Do I need instruction on how to use it? Do I need an app that is specialized for my student? And who's going to do the training on that? After the student's needs have been identified, the goals are written. And then we determine what kind of services are going to help support those goals. The IEP team decides what's appropriate placement for the student. Placement is not a place. It's where the services and the supplementary aids and services, what does that look like, and where's that going to happen? So the district might have a program for students with autism within their district. The student may be suggested, or you may decide that's where we want the placement we want, because we want that access to that autism specialist. Doesn't mean that the student's going to be in a special classroom all day long, but they'll be in the general education classroom of that school with easy access to a teacher or teachers who understand autism and work well with students with autism. And every classroom teacher understands that she may have a student with autism within her classroom, and she'll be supported helping that student be successful in her classroom because the services are at that school. That's the placement. It's describing the services that the student needs in the least restrictive environment. And so that student still has access to general education, but the district has decided that because of their budget and all this, they're going to have the services kind of grouped in one space. Take a close look at that. I mean, you can say no to that, and you can say, doesn't seem like a good fit, or it's too far from home, or whatever. But, placement is not just a place. It's the services that are being delivered to the student. And so some of those services may be delivered in another location. There was a suit years ago for a small district in our state. It had two middle schools. And one middle school was an old building with stairs, and one middle school was a new building they built that was accessible to wheelchairs and people who use wheelchairs. And the parents wanted their student to go to the old building because that's the elementary school that he had attended fed into that old building, and that's where his friends were going, to the old building, middle school. And so the parents because of friendships and because of their neighborhood. They wanted him to go to the old building. And so it came down to a due process, and it was determined that the student would go to the new building because it was accessible to wheelchairs. And the district had an obligation to provide an accessible classroom, an accessible building that the student could access, and it happened to be in the new one. And parents lost on that because the district was fulfilling its need for providing a free, appropriate public education for a student in the new building. Services support access to general education curriculum as much as possible. So once again, you may have an autism program, you may have an accessible building, you're providing access. High expectations are important. We want to have high expectations for all of our kids, not just kids who don't have IEPs. It's important to, you know, raise the bar for learning for all of our students, because when we do, they rise to the occasion more than they don't. And exposure to what all students are learning is so important. We're helping them become the people they're going to be as adults. We want that to be informed young adults who love learning. So it really is important to expose all students to what they're learning. Well, I don't know why he's in geometry. He can't even add and subtract yet. Well, he needs to be exposed to it for one thing, and he's going to learn, and we have to figure out how he can learn. Well, I don't see why that student needs to learn the Constitution. He can't even read. He's living in the United States. He needs to be exposed to the Constitution. It's important. It's not for us to decide and make that judgment of what a student should or should not be learning. And when we do remove a student from a classroom because we feel it's necessary, we have to look at what is he missing by leaving? How are we going to make that up? Well, this is the only time we have to do specialized, math, or this is the only time we have to do, well, what's he losing out on? And how can we make that up for him? And then progress reports should be sent home, typically once every quarter with report cards. So as often as the student gets a report card, they should get a progress report on progress towards specific IEP goals. So our goal is that he's going to increase his reading speed from this to that. Are we doing that? Are we making progress? Do you think we can hit it by the end of the year? If progress is not evident, then that's when you might want to call another meeting to say, we're trying. We were making a good guess. We were looking forward to, thinking we're going to be able to meet it. Did we meet it? I think we need to change things a little bit. It doesn't mean that the teachers aren't doing what they said they were going to do. When we write a goal, we're taking a crystal ball and we're looking into the future, and we're going, I'm guessing that we can make this much progress if we do this for the student. That's my best guess. Educated guess, but it's a guess. And that's why these progress reports are so important, because it's checking us to see if we guessed right. And if we didn't, we need to make adjustments. That's all. And it's also always good to ask questions and seek clarification if you need to. Why do you think he's not making progress? I'm not accusing you of not doing your job. I'm just saying, what do we need to change? Students with disabilities do have an extra layer of protection when they're being considered for disciplinary action. And that, especially if you have a behavior plan in place, or you need to have a functional behavior assessment, you might say, you know, we really should get a functional behavior assessment. We need to see what the function of this behavior is. And then how can we put a plan in place, or a behavior intervention plan in place to help the student with these behavior considerations. You can be suspended for 10 days during the school year. And if you're suspended for 10 days all at once, or if you're suspended for 2 days every month until the end of the school year, once it adds up to 10 days, then you need to have a manifestation meeting to determine, is this behavior part of the disability? Is it a manifestation of this student's disability? And, you know, a lot of times, especially kids with ADHD, especially if they're very impulsive, they go, you know, they'll do something really, you know, dumb or over the top. And then you have the manifestation, and the student will go, oh, why did I do that? Oh, I'm so sorry. And sometimes schools come back and say, he knew what he was doing was wrong. This was not a manifestation of his disability. Then maybe it was a manifestation of his disability, because regret afterwards is also part of that whole thing about being impulsive. I'm impulsive, I did it. Ooh, I wish I didn't do that. It would be nice to have a rewind for some actions, and they wouldn't do it again. They understand it. However, the disability got in the way, and it was a manifestation of his disability. Your role as the educational surrogate parent during this disciplinary process is to say, you know, we need to really look at this, and what are my rights and what are my students' rights during this process? And do we need to have a functional behavior assessment? And do we need to write a behavior intervention plan? There was one parent who had a student, and they were working on life skills, and he was a young man who part of his experience in life was having Down syndrome, and his job was to pack his lunch every day for school. And he was in high school, and he was doing a good job packing his lunch, until one day he pulled out his lunch and he pulled out a beer for lunch. And he was being suspended from school, disciplinary action, because you cannot have alcohol in school. They had to manifestation determination to determine whether or not bringing a beer to school was part of his disability. Was it a manifestation of his disability? Well, he was responsible for packing his own lunch. His dad often had a beer for lunch. He thought that was pretty normal. So after it was explained to him that he couldn't have a beer for lunch and he could have a pop for lunch, then it was determined that yes, it was a manifestation of his disability, and he did not suffer the consequences that a student who did not have an IEP and had a different understanding of what lunch consisted of. And so he was not expelled or suspended from school for bringing a beer to school. And as a parent, you have the opportunity to examine records and participate in school meetings. Examine those records. You know, they may not have many records, or they may have a whole, you know, foot, they may be a foot tall, but it helps you get to know the student. So examine the records. You have that opportunity, and you have that right as a surrogate educational parent. You also have the right to request an independent educational evaluation and an independent educational evaluation at school district expense. So if they do an evaluation and you don't agree with it, or you think that it needs to be more in depth, or you have a problem with it, you can ask for that individual educational evaluation. Prior written notice and content of prior written notice, or PWN, you have that right. So if you request something, then the school request it in writing. The school needs to respond to you in writing. We got your request. Here's our response to your request. Here's what we're going to do. You should receive your procedural safeguard notice at the very first of this whole, process of becoming an educational surrogate parent. And that's so, not because we expect there to be a problem, but it's your right to know what your procedural safeguards are. And so you keep them in a place that you can read them and read them. Electronic mail, emails, if you email a request, they need to respond to you in writing. That's considered writing. It's also kind of an electronic record of this whole procedure. So if you meet with the school, I suggest that if you're talking to them in person and you're having this discussion, it's just kind of nice if you go home and you email back the teacher or whoever was involved in the conversation, say, thank you very much for the conversation. You said this and I said that. Here's my understanding of how we're gonna move forward. It's in black and white. It's right there. It's not, I don't remember saying that. I didn't say that. Yeah, here it is. This is when it happened. And here's the conversation we had. And it just keeps the record. It's keeping a record. You have a right to mediation. Mediations through the Colorado Department of Education. And the mediator does not make decisions, but it conducts the conversation. And hopefully you come up with a mediated agreement that everybody can live with. State complaint is you have the right to file a state complaint if the school, everyone agrees. These are the what the school is going to do to help the student move forward and be successful at school, and then it doesn't happen. That's a state complaint. The IEP says that he's going to receive this service. He's going to receive, he's going to work 30 minutes a week with the social worker. The social worker hasn't shown up in 2 months. That's a state complaint. It's a service that the IEP team agreed he needs, and it didn't happen. Due process complaints and civil actions. You have the right to proceed in that direction if you feel it's necessary. A due process is a trial-like setting with an administrative law judge, and the judge hears the evidence, and both sides present evidence, and then the judge makes a decision. And then the transfer of parental rights at the age of majority. And age of majority in Colorado for students on IEPs is 21. So, or until you graduate high school with a high school diploma. So then the district's obligation to the student would end at that point. Then student disciplinary procedures. You have a right to be, as a parent, involved in, the student disciplinary procedures, and to keep you informed and to, decide what's going to happen next. When more assistance is needed, you can have facilitation by an impartial facilitator, and it can be very powerful. Our state now has this new process that has a lot of promise to it, and it's a facilitated IEP. And so the Colorado Department of Ed can appoint a trained person to come and conduct the meeting, to facilitate the IEP meeting, to make sure that all voices are heard and that participation follows an agenda, and that you reach consensus, maybe not total agreement, but you reach consensus throughout the process, step by step, so that when you're at the end, all the way through, you've reached consensus, so at the end you have consensus. So it can be a really good way to conduct a meeting for educational surrogate parent especially. And when you're in this, for a student who is in a place that they never wanted to be. So the purpose of facilitation really is to maintain that communication between all the members and to use good active listening skills to help the IEP team develop into ask questions that have some meaning to them and that people really are getting on the same page with one another. And to stay on task and to stay on time. It's really important. And to assist the team in understanding where resistance is coming from and resolving conflicts through consensus and decision making for the whole team. And that the focus is always the needs of the child. It does have a lot of promise, and it's been fairly successful in our state since its conception. So it's not advocating. So the facilitator is neutral, and the facilitator is neutral to this whole process, but making sure that the process is respected and followed. A mediator or confidential mediated agreements that it's going to stay, what happens in Vegas stays in Vegas for part of this. And it's a mediator is not a facilitator. It's not due process. It's not the administrative law judge making the decisions, and it's not someone, a third party, leaning one way or another in this whole process, but having the team learn to work together as a team. So if you request IEP facilitation is received, and it's voluntary, so both parties have to agree to it. But it really is a good idea to help the team focus and help the team stay on the agenda. Then a facilitator is assigned, and it'll be somebody in your area, hopefully, that can help, with this whole identification. The facilitator would contact the district and the parents at the same time to develop a mutually agreed upon agenda. That's really important, that we get agreement from the get-go. And before the meeting, the agreement to participate in the IEP facilitation form is signed by both parties. And then the facilitator begins with introductions and review of the agenda and following the revisions made at that time. And then they're evaluated after the meeting. So mediation is a voluntary process. Both parties agree to using a mediator, and a neutral mediator assists the parties in reaching a resolution. And if they do reach a resolution, that's binding arbitration at that time, and you have 3 days to kind of change your mind if you need to change your mind. Our state in the past, and I think we're still using administrative law judges as mediators, and we've, but they're acting as a neutral mediator. They're not acting in that process of administrative law judge. And a due process complaint administrative law judge would oversee the hearing, and it's much like a court with testimony and decision making made by the administrative law judge at the end. State complaint officers, a written process, conducts an investigation and interviews the parties, and then a decision is issued by the state complaint office. And you can, it's more of a written process instead of a face-to-face process. So the summary is that you get a written notice. You have a right to prevent that prior written notice of what's going on, what you ask, what the consensus was. You have the right to participate as parent and make parental decisions. You have the right to consent to conduct the initial evaluation. So even before placement starts in special education, you would have that right to say, yes, I give my permission as a parent for evaluation to see if special education services are needed. Then as the surrogate educational parent, acting as parent, you have the right to ask for an independent educational evaluation if you disagree with the school district's evaluation. It could be all the evaluations, it could be one evaluation, but you have that right as a parent. You have the right for confidentiality for the student. You get to read the records. You get to talk with the people with whom that student lives. You get to, interview the student and get to know the student, and you agree for confidentiality too. And then disagreements, if disagreements come up, you get to act as a parent would act you can ask for IEP facilitation, for mediation, state complaint, or due process. So you have the right, you hold those rights in your hand for the student. It's a really important process, but it's a really important voluntary act that you're making for this young person who needs someone in his corner to make sure that their rights for education are protected. And if you have any questions at all, please contact Peak Parent Center at 719-531-9400. And we thank you very much for your consideration, for considering to become an educational surrogate parent for students in need in our state. Thank you. And here's our contact information. We're so happy that you've watched this, and please consider volunteering for some young person within your area. And goodbye. Okay, what do I do now?